So welcome to today's webinar. It's called Practical Tips on Caseworkers Supporting Clients Living with Family and Domestic Violence. So first of all, I'd like to do a bit of a welcome to country. So I'd like to acknowledge the traditional owners of the land on where we're airing from today. That's 44 Herschel Street in Brisbane City. And pay our respects to elders past, present and emerging. So before we start this webinar, I want to quickly flag that this webinar is for community legal education purposes only. Okay. And so who we are. All right, so I've got today two lovely presenters. We've got Paula Bould from Queensland Courts. Say hi.
Hi everyone.
And we've got Fionna Fairbrother from Legal Aid.
Hello.
So we're very lucky to have both organisations here coming together to collaborate on this webinar for you guys. But before we get started, I'll just go through some webinar housekeeping. So if you'd like a copy of these PowerPoint slides, go to your right-hand toolbar on your screen right now and go to the handout section. And you can download your handout from there. If you've got any technical issues, the phone number on the screen to call is on the slide there. And this webinar is being recorded, so afterwards we'll put it up on YouTube and it will also be transcribed. So we'll let you know when the recording is available on YouTube to view. Okay. If you'd like to ask us a question during this webinar, please do so, but we'll save your questions till the end. We aim to make this presentation 40 minutes and then we'll spend 20 minutes at the end going through all your questions. Okay, I'm going to start with a poll here because we'd like to know about you guys and where you're from. So I'll just launch our first poll. We'd like to know, what area do you work in? So please vote. We'll give you a couple of seconds to vote. Okay. All right, so I'll just close off that poll now and we'll share with you where you're all from. So you should see on your screen now that 72% of you are from Southeast Queensland, but we've also got a number of you from far North Queensland and regional Queensland and some even from interstate. So that's really great that we've got some people from our regions linking in today. Okay. All right, I've got another poll just to find out a little bit more about you guys, and so you guys all know where each other is from. So where do you work? Do you work in a women's refuge, domestic violence support service, community support service, men's support service, or something else? I'll just give you a couple more seconds and then we'll close off that poll and you can see the results. Okay, I'm going to close off that poll now. That's great. Okay, so 46% of you are from a community support service, 12% of you from domestic violence support service, some of you work in women's refuge, some of you in a men's support service, and 37% are other. Okay. All right, now this is a question that we'd like you to answer as well, because the majority of this will be about these special forms. So have you used the DV1, DV forms before? Give you 5 more seconds and then I'll close off the poll. Oh, great. Okay, so I'll close off that poll now. Okay, it seems like 87% of you say that you have not used the forms before. So that's really good for us to know because we'll help you understand these forms today. Okay. All right, and then one more poll. This is our last one, I promise. So who are your clients? Are they people who are from a culturally and linguistically diverse background? Are they LGBTQIA+, Aboriginal and Torres Strait Islander, men or women? Okay, just waiting for you all to finish voting. There's 63 people here today, so I'd like to see all of you voting. That's great. Okay, I'll just close off that poll now. Okay, so we've got 47% of you who have clients that are women. A large proportion of you have people from a culturally and linguistically diverse background. And we've got some representation from those other groups as well. That's really good to know. Thank you guys for voting for us. Okay. So I'll go through what we're going to talk about today, and that's we're going to give some practical tips for you guys and show you how to use the Queensland Courts online forms, DV1, DV4 filing forms, and some tips about attending court. And then we'll also talk a little bit about helping people living with domestic and family violence, and how to get help and navigate the justice system, how Legal Aid Queensland can help, and other referral pathways. Okay, so I'm going to hand over to Fiona to get us started. So I'm going to move out of frame because it's a bit awkward with three of us here. So we'll do a bit of musical chairs.
Yeah. So good morning, everybody. So as Ellen said, my name's Fiona, and so I'm just going to start with a little bit of the definitions that we might be using and that you need to be comfortable with if you're helping clients through this process. So the first one is the aggrieved. So the aggrieved is really the person who is in need of protection. So sometimes they will be the applicant, but in a police application, they will be the person who's in need of protection. The respondent is the person who we're saying the behaviour needs to stop. So they're the person who's been using the acts of violence, and there's behaviour that we're asking for that person to stop that behaviour, stop those acts of violence. So the DV1 is the application for a protection order. So that's if you've never had a protection order before or your protection order's expired, that's the form you'll be using. So a lot of applicants, that's the form that we have used. It's the DV4 is the application to vary a protection order. So that's if you have a protection order that's already in place that hasn't expired, and you're either wanting to extend the expiration date, or you're asking for some more conditions, or you're asking for some conditions to be reduced. You might want an exception to those conditions. You might want a named person to be removed from that protection order. So that's really where you're wanting some change to the current protection order. The extra conditions, so that's where you're needing to have some conditions to say that maybe not to use the social media to communicate. You're wanting the person not to come within 100 metres or 50 metres of where the aggrieved lives or works. So that's really looking at you needing some extra conditions to make that aggrieved or the person in need of protection safe. And so the extra conditions really are added if in your application you've said this is the extra behaviour that you're worried about and you need that to stop. So duty lawyers, they're lawyers that are at court, and they'll be at the court in only a number of the magistrates. So they're not in all of the magistrates' courts, and further into this presentation we'll show you where they are. Now the support worker, they're actually the worker. There's in some courts there's men's workers and women's workers. In other courts they will assist both applicant and respondent, men and women. So that's really all the definitions. Is there anything that I've missed?
No, I think you explained that well, Fiona.
Okay. So to go on to the next slide, do we? Sorry, it's not in a slideshow mode for us.
So you can just click on the next slide, just as you normally would. Okay.
So this is some practical hints and tips when you're wanting to help the aggrieved. So it's important to think through, does this person have the ability to take the application, file it, attend at the mention and then go to a hearing, or are they quite stressed and will they not be able to do that? So, or is it unsafe for them to go to court? So it's really looking at, is the better option to help them to apply for a grant of legal aid, or is it to assist them to complete the protection application? Often we talk with the client because it's really their choice as to what do they have enough energy today to do. And they might have really, all they want to do today is to complete the application to go to court and to get a protection order, and that they might need some help later with the legal aid application. So it's important that if you think, yes, they do need to have a lawyer to represent them, that you consider getting legal advice for them. So there is the 1300 65 1188. That's our call centre, and they can link that client into getting some phone advice or some face-to-face advice at one of our legal aid offices. So, and it just depends on the urgency for that client and where you're living. So for the people in regional areas, it might be better that they have the phone advice. For people that are in southeast Queensland, it might be easy for that client to come in and see somebody. We've also got some referral pathways. So I'm not sure if you're an organisation that has a referral pathway to a legal aid office. And in those, we can assist highly vulnerable clients to have a call back. So it's so that they don't have to keep saying their information over and over again. And it's about the legal aid taking responsibility for ringing that client. And therefore the clients that don't really have the ability to ring us, they're highly vulnerable. We don't want to disempower them. These are clients that wouldn't come to us without that extra support. So the next part's about, this is where the next slide is in relation to where are our duty lawyers and where are the specialist courts. So I think the map there, it shows that we're in 22 magistrates courts, and so the first one started, that was in Southport, and Paula was one of those services down there that helped us to be innovative. And so from that Southport specialist model, we've taken a lot of what the learnings are there. Yeah. And we've tried to apply them depending on which court, what suits that court.
That's right. It's needs to be adjusted according to your region, obviously.
Yeah. So each magistrate court would look differently, and so we're just here to help you with the form and maybe linking in with other services as well. So if you can see on the map, you know, Mount Isa, the court in Mount Isa would look very differently from a court in Southport. So, and the court has very good systems to make sure that everybody can link in and be kept safe.
Correct.
Yeah. Okay, so I'll hand it over to you, Paula.
Okay, so the next slide we have, I guess, is now we're going to be talking about where to start. So we're talking about the online forms specifically today. So that's the online form for DV1, which is an application for protection order, and DV4, which is what Fiona spoke to before about bearing an order. But I will just say from the outset that there are paper forms that are available at any courthouse around Queensland, and you can also access the paper forms on the Queensland Courts website. So you can see on the screen there now, we've taken a snapshot of the Queensland Courts website where you will find all forms that you need with domestic and family violence. So you'll see, not only see the online version of the forms, you'll see the paper forms, but you'll see all different kinds of forms for subpoenas, etc. Everything that you need to know you'll find on that website. It's also not only there for forms, it's a wealth of information if you're starting out in this area or you're looking for some pathways. So the Queensland Courts website has a dedicated domestic and family violence page. There's some really interesting videos on there, referral pathways, current data and statistics. And yeah, it's just a really useful page to go to when you are initially starting out. And it's for service providers and for victims and respondents of domestic and family violence. One thing just to note from the outset that you'll see on the screen there is a quick exit link, and that's obviously placed in there for safety precautions. So if you or your client are completing an online form or viewing the domestic violence Queensland Courts website page, you can exit that page very quickly by clicking on the quick exit link, and it'll take you to either ABC TV Guide or Facebook. There's also information there about planning to use your technology safely. So there's instructions there to take you through how to hide your visit completely so it doesn't come up in your browser. So these are the kind of things you might want to have a discussion with your client about at the outset before beginning to complete a form. Another item that's quite important to mention initially, and I talk to this from experience at the Queensland Courts, and that is just reminding our clients that the information that is contained or the information that is put in the domestic violence application does need to be served in its entirety upon the other party, upon the respondent. So if we're just mindful of that while we're completing the form. So that really comes into play, particularly when we're talking about addresses. If someone is at a safe address and doesn't wish to disclose that address, we need to be very, very mindful when we're completing the form that we're not inadvertently disclosing that address throughout the form in another way, perhaps a contact address for your children or for your relatives or something like that. So Queensland Courts have what's called the aggrieved confidential details form that you can see on the screen there at the moment. And that's for clients who do not wish to have their address disclosed to the other party. And that is a separate document that is to be completed and handed into the court. The court is the only party who retain that information, and it is kept as confidential. So that information will not be released in any format to any other stakeholders or clients. This document can be updated at any time also. It's very important that Queensland Courts knows your current address so we can communicate with you. So it wouldn't be uncommon for us to have several confidential address forms on file during the course of a domestic violence application, and that can be located on our Queensland Court website as well.
I think it's also important to say, before you start with the client to fill out the application, you really need to have set aside an hour or so with that client. So it's not a document that you can complete in 5 minutes. And it's something that the client might be quite distressed when they're remembering some of this, what's happened to them. So it's important that they're in a private place, that it's somewhere that if they're getting upset, that, you know, that they can maybe go and come back again. So that's why it's really important that you're if you're supporting this client through that, it's about saying that right at the beginning, that this might be quite a confronting form to fill out, that it might be distressing, and that's making sure that you have those support networks. And we talk about that further into the presentation.
Yeah, that's correct, Fiona. So, for example, if your client has to go and pick up their children from school in half an hour, it probably wouldn't be the best time to commence filling the form. It would be better to make an appointment so they can come back and really focus on the content of the form.
Yeah. And also, you know, it is about, are they safe to go home that day? So it's about talking through about safety, whether they are safe to do the form at home. So it might be just helping them to feel comfortable to start the form, what they need to get together, and that they might be able to do that at home. So it's just a couple of those questions before you start into the whole process, and really understanding if this could be a distressing time. But also, you might be the first person that they've actually come to and said, I need to do something. So it's really important that if you're in the community, that you listen to what the client's saying and that you're very accepting of what the client's process is. Okay. So
we might move on to the next slide. I think.
I'm not so good at moving the slides.
Paula can be in charge of that.
Yeah.
Okay.
Do you want? Are you this one now?
Yeah, that's right.
Oh, so we just click on those.
Yeah.
Okay then. So we've gone through the safety form, and have we spoken about the safe room? So not every court has a safe room, does it?
No. So I will just discuss the safety form. We haven't touched on that just yet. So this is another form that you'll find on the Queensland Courts website. And Queensland Courts are committed and dedicated to the safety of all court users whilst they're in the court precinct. And this particular form here is designed to assist people feel safe when they're attending court. It's a safety form that if you complete, if you have any fear about when you're appearing in court. So, for example, I'm just going to give real life examples. Perhaps the other party might be sitting in the car out the front of the courthouse, or the other party's family might be on the last occasion sitting in the waiting room, you know, behaving in an intimidating manner. There's lots and lots of different scenarios that people have. So I would encourage your clients, when you're speaking to them at the initial outset, as Fiona said, to discuss how they feel about getting to court and how they feel about their safety at court. Fiona did mention that, yes, not all courthouses around the state are purpose-built for domestic and family violence, and not all courthouses have safe rooms. Some of them have newly purpose-built safe rooms, others don't. But every courthouse has access to this safety plan document that we have here. And so you would complete this document in conjunction with your client and submit it prior to coming to court. And the registrar at the court will take a look at that and formulate an action plan or a safety plan for when your client appears in court on the following occasion. So it could be something potentially that your client would need access to the support room or the safe room so that there's no interaction with the respondent whatsoever. It can become quite detailed to, you know, safety plans that perhaps clients are granted access to the building prior to commencement, prior to the doors opening, and they're embedded inside the building, and then they are escorted out of the building, out of a side entrance or something, you know, with QPS. So it's a collaborative approach. It's really, really important to note, though, that this is a safety plan that's formulated by the registrar, and it is specific to your region, and it's also specific to the needs of all the other court users as well.
Yeah. So it depends on what's available at each magistrate's court, but also if the registrar assesses that other services need to be informed. So sometimes you'll have men's workers or women's workers there, or you might have a court network that might be able to sit with that client. That's something that the registrar is able to send on that email the day before, and it flags it with these other services so that we can work with your client depending on the needs. But as I said, that is the registrar that decides that, and we have a really good support process for that. Yeah,
it's a terrific process, Fiona, and I've seen it work firsthand. And what it does, it really embeds the confidence in your client when they're coming to court, so that they know that someone has listened to them. They know that there is a plan in place. They know that their presence is being expected at the court, and it really increases their confidence in the system and their confidence in appearing before the court.
So as soon as you can get that form in, it's the best way, but so making sure that it's the day before, because on the day it would be too late, really.
Absolutely. The very minimum would be the day before. And once again, this is very similar to the agreed confidential form that I was talking to earlier. It's not uncommon to have several safety plans on court file or in place during the course of a domestic violence application, because as our audience well and truly knows, someone's safety landscape can change at a moment's notice.
And so that's really important also when you're thinking through, is it safe for them to go to court, or should they be getting legal advice, and should they be getting someone else to represent them? So I think that goes on to the next slide. So does your client need legal advice? So it really is about, you would be there assisting them to complete the form. If they feel that they need to know what's going to happen, what might happen with their children, what might happen if they don't get the protection order, it might increase their anxiety a lot. So that's where we would recommend that they would get legal advice, and that legal advice before the day, so that they can understand what is the process that might happen at court, how that will impact on their family, and how it might work with the respondent into the future. So it's really about saying an application for a protection order is not a criminal charge. It doesn't mean that the respondent's going to go to jail. It's really about saying this behaviour needs to stop now, and the community supports that behaviour stops.
So with respect to completing the relevant forms, so the application for DV1 or DV4, the applications for DV1 and DV4 are available online, so they're the only ones that are available online. I'd really encourage you all to take a look at the online version that was developed recently with Queensland Courts with strong collaboration from the community. It's a really great training tool, if nothing else, for yourself, and I know that I've most certainly gone through it just to refresh myself several times. It's designed in such a way that it's designed with the victim in mind. So if you're used to, or you have completed the paper format before, you'll notice a slight difference in the format of the online form, and that is once again thinking of the impact on the victim. Fiona, you spoke before about the re-traumatisation of a victim of domestic violence and having to retell the story over and over again. Yeah. This form is designed in such a way that you would, so for an example, you place enter the respondent's details in the form once, and then it auto-populates all the way through the rest of the form. And that's not just from an efficiency side of things. That is so that the victim does not have to repeatedly write that person's name and see that person's name and re-traumatise them. The DV1 form also, you'll note from the outset, it delves quite deep into the reasons for applying for a domestic violence order very quickly, rather than filling out all the other information, names, addresses, dates of birth and things like that, because it can be a really exhausting experience, mentally exhausting experience. Yeah. And quite traumatic. So we're looking at extracting that really important information initially, and then you can come back to that form later and fill out all the other little bits of information. I will just also point out, so the DV application and the DV form to vary can be filed at any courthouse in Queensland. It doesn't need to be in your local region. So if you have a client with you who has fled domestic and family violence, for example, you can lodge this application at any court in Queensland.
So just wanted to inform everybody about what you would need to attach to those forms. So you will have to print out the form. It does need to be signed. And if there is some relevant information that you want the magistrate to know, so maybe there are some parenting orders that are in place and you're needing to have a little change to those orders, or you must inform the court if there are parenting orders in place. But there might also be some things that it might be really horrible text that you're getting, and you want to have a copy of that, the worst text. You want that attached so that the magistrate's aware what is really happening for you and how it's making the aggrieved feel, you can attach that as well. Thanks, Fiona.
Point 4 speaks to having the form signed by a Justice of the Peace.
Yeah.
So that is that comes under the legislation. So that document must be filed in person at a courthouse. So if you're completing the form online, you will need to print that document out and have your client come into the closest courthouse to have their signature witnessed by a Justice of the Peace. Generally, most courthouses you will find a Justice of the Peace embedded in the building there. Otherwise, Queensland courts will be able to direct your client to where the closest Justice of the Peace is. It's also a really great opportunity to attend the courthouse with your client and have them have a look around the building and have a chat to registry staff and ask any questions that are relevant to them. Registry staff are a wealth of knowledge when it comes to domestic and family violence. So by bringing the form in to the registry to file it in person, it's a great opportunity for your client or yourself to ask any questions that you might have.
So some of those questions might be on the day, which court do I go to, and it might be, what time can you come, all of those questions and just makes the client feel more comfortable so that the first day they come to court is that they're actually feeling a little bit more relaxed. Can't say that you're going to be relaxed at all, but
yeah. And I've seen that time and time again. Aggrieved parties will want to have a look at the courtroom. They might even want to have a look at the courtroom setup. This is where I will walk into the courtroom. This is where I'll be sitting. It just makes them feel more comfortable knowing where they're going to be going on the court day.
Yep. Okay.
And point 5, I think we've already addressed. So when you go into the court to get your document witnessed by a Justice of the Peace, the registry staff then will allocate a court date and complete the summons. So it's not necessarily the case that you're going to be seen by a magistrate on the very same day that you go in and lodge the form. That is dependent on where you are in the state. But the registry staff will be able to, number 1, advise you of the next available sitting days, have conversations with you regarding safety. And also, really importantly, the registry staff can offer you some referral options. So different referrals to different agencies that are in your local community.
I think this is about the form itself online.
Yeah, this is the online form that I was just discussing earlier. So,
so you don't have to remember what I said about the aggrieved, it's all online.
Yeah, there's definitions that prompt all the way through, and that's what I really, really like about this form. And as I was saying, I'd encourage you to actually get online and have a bit of a go at it yourself. So there's prompts that come up all the way through, giving you definitions, giving you referrals to local agencies in your community and explanations about what's happening. Information on the format and what to include. Did you want to discuss that, Fiona?
Yeah, so that's probably in my next slide. I was going to go more on about some tips for completing the form. But have we finished everything you wanted to talk about lodging the form?
Oh, I'm just going to give you a little bit of data with respect to this form. So in the past 6 months, and this is very recent data, in excess of 10,000 people have viewed the DV1 online form over 15,000 times, and over 1,700 online forms have been submitted at the courts. That's for the DV1. The DV4 application to vary is slightly lower. But yeah, that shows that it's a very well used form.
It is a document that I think you can have a look at, have a go at completing without your client so that you're comfortable with the process, so that when you have any clients that come through, you yourself are familiar with it. Similarly, do you have a sufficient Wi-Fi and do you have a printer and all of that that's going to work for your client? So the next part was just tips for completing the form. So this is where I wanted everybody to sort of really understand that it must be a relevant relationship. So it's not that you think, oh, there's been some acts of violence, so therefore this is the form for me to complete. It really is, you have to fit within the legislation of what is a relevant relationship. So, and the legislation, yes, it is you know, an act, but it is written for people to be able to read, and it gives really good examples. So if there's a possibility that you think, oh, I'm not sure if they're in a relevant relationship, it's easy to Google the act. It's really easy to look under what is a relevant relationship. So is it an intimate personal relationship? Is it a family relationship? Is it an informal carer relationship? So the intimate personal relationships, if you're a former spouse, a parent of a child, that maybe you're engaged, or that you're a couple. So, and it's really important, there's different sections that give examples of, well, what is a couple relationship? What do I have to show to fit within that relationship? So it's useful either to get legal advice or for the client to read through that themselves. So you don't really want to complete the whole form and then find out they're not in a relevant relationship. And so therefore, the magistrate might be quite sympathetic, but they can't do anything for that situation.
And that's the first hurdle that the court needs to get over as far as even considering the application, isn't it? They must be
within that relevant relationship.
That's right. The magistrate must be satisfied that it's a relevant relationship before they can move on to any other steps.
And so that doesn't mean that they can't be kept safe. It just means that the court's not going to be able to assist them with this form. So it is important that if they're feeling unsafe, that they still talk with maybe some services that can help them with their safety. So also understanding what's a named person. So that's someone that there has been an act of family violence towards, and that they want to be protected. So it could be a child, it could be a person that is related to the aggrieved or in a relationship with the aggrieved, but there must have been some act or exposure to an act of violence. So the next one was in relation to what are some of the reasons that you need to put in your protection order application, so application for a protection order. So you must make sure there's enough detail there that the magistrate can understand what's the behaviour that has to stop. So it must have the normal ways that you'd structure a sentence. It's who, what, where, when. But within this, it's also looking at how did it make the aggrieved feel? So did it make them feel intimidated, stressed, anxious? Those are all the information that the magistrate also needs to know about. It's important that you have some headings. It's important that you number the facts. And it's important you keep it to facts. You don't say such and such said to such and such that this happened or might have happened. It must have happened to that person. So it's really a fact or a piece of evidence. So the standard for the evidence is not beyond reasonable doubt. It's on the balance of probabilities. And so you don't really understand that. It's a lower test, but it is important that they get some legal advice about that. Also wanting to talk about temporary protection orders. So it is important that if you're not feeling safe or that the person's not feeling safe, that they actually talk with the domestic violence service about practical tips about safety. But it is also important for you to put in there that if you need a protection order a temporary protection order before the matter goes to hearing. So this might be the first time it comes to court, we call that a mention. That's where you might want your temporary protection order. So it's important to say why you're worried and that you need something in place as soon as you get into court. And then it's up to the registrar to decide, is it something that needs to be seen urgently, or is it something that can wait for the next mention? So that depending on the courts.
Yeah, so the registrar will make a referral to a magistrate, and the magistrate will make that decision.
Yep.
Yeah.
So it's important you complete the form, put in the relevant area, what you're worried about now, and what's really happened in the history of all of the events. I think that's about all for the tips.
Yeah, just before we move on, Fiona, if you don't mind, there was
Yeah.
something I should have mentioned earlier.
No worries.
It's quite a key point that I want to just reiterate. The domestic violence forms, the online form 1, you can now save. You can save it online.
Yeah.
So that's reasonably new, and I just wanted to point that out. So you save it you can save it as a PDF and then come back and complete that form later.
Great.
Yeah.
So a few years ago that couldn't happen, and that was from feedback from the community, but because the technology wasn't yet at that stage to make people safe when they were completing the forms. And so the technology has improved, and Paula's been on top of that, making sure that that happens. And so that should help a lot more clients.
Okay, so the next slide we have, really, I've actually already addressed I've spoken to the confidential address form already. I'll just make sure there's no other points here that I want to raise, but I think I have
questions soon. So.
Yeah, we are starting to run out of time, so I might skip through that. I've already brushed on that.
So I'll just click down. Where are we? Okay. Talking about the plan. So these are all the supports. I've spoken a little bit about that already. So the domestic violence duty lawyers, if they are in a court near you, there should be one for both the aggrieved and the respondent. So you'll see, they will see a separate duty lawyer, and those duty lawyers will either give them advice about the process today, how that impacts on their lives. And this is so that the parties can take away the order or what happened at court that day and understand how to put that into practice in their everyday lives, and what it might look like, whether they can see their children or not, how that impacts on whether they can go to the school or whether they can't go near the school. So it really is about giving them that information and stopping that behaviour that is the worrying, concerning behaviour. And that's why they have, at a lot of your courts, they will have the support networks there to help you as well. So the women's workers, the men's workers and the court network are also there to help clients, to give them a link with what's available in their community. So every community has different services, and that's why it's really important to talk with your local court and your local services, so they'll let you know what's available in your area. And ATSLS is available to assist clients if they are in that area and that there isn't a conflict. So all lawyers must make sure that we're not conflicted in giving you that service.
Continuing on with the supports at the court, I just wanted to touch on the interpreter process that's available with all domestic and family violence applications in Queensland courts. And I do note that we have quite a large percentage of participants today who are from the CALL community. So I just wanted to highlight the fact that Queensland courts has a policy with respect to interpreters, and we will engage an interpreter on the first occasion for a domestic violence application by either phone or video conferencing, and that is free of charge for your client on the very first occasion. And the magistrate will then make a determination as to whether or not an interpreter is required from that point on. But there's most certainly the interpreter available on the first occasion. There is no questions asked, there's no fees involved, and it's really, really important because we do not want any members of our community not participating in the court process because they feel that perhaps they might not be able to understand the process, or even perhaps that they might not have money to be able to pay for an interpreter.
And that's also with the duty lawyers. It's really important that the duty lawyers will engage an interpreter so that the client understands what's happening for them on that day. The only barrier for duty lawyers is that we haven't had the opportunity to book an interpreter. So some languages, there may not be interpreters available straight away. So in those situations, we will let the court know that we haven't been able to use an interpreter, and we might need to adjourn it for a couple of weeks so that we can book that client in, have an hour or so to talk with that client and to really for them to understand what is happening, what's the process, and how that impacts on their everyday life. It is important that you make sure you put down what language and what dialect that the client needs. And if it is a language or a dialect that there are not many interpreters, then they will particularly book a time sometimes to get that particular interpreter. So if it's not a common language.
Yeah, and I do note that we have once again, a large percentage of representatives here who look after Aboriginal and Torres Strait Islander people, and the Queensland government or Queensland courts have just brought on a service provider earlier this year specific for Aboriginal and Torres Strait Islander community members. So touching on what the registry can do for you, we've talked about it a little bit throughout this presentation today. They're just a wealth of information, the registry staff. They can provide referrals to different agencies in your community. They can help you with obtaining interpreters, talk you through the court process. There's so much knowledge with the registry staff, and there's a lot of training that takes place behind the scenes.
Yeah.
Obviously, Queensland Courts is very dedicated to its domestic and family violence courts, and the staff are suitably trained for that. One thing that I will point out that registry staff are unable to provide, and that is legal advice.
That's right.
So that's where legal aid come in. Registry staff are there to accept the documents and provide the procedural advice about completing the form and having the matter listed and referring and engaging in the community. With respect to specific legal advice, that's where referrals are made to legal aid.
Or community legal centres. So most courts, most of the registry staff have like a referral list to what's happening in your local area. So that's why we said, you know, go to the registry and they can give you that information.
Right.
So it's encouraging the client to do that, to feel comfortable to take that next step, and that the registry will be supportive of what process is needed for that client.
That's correct. Yeah.
So I just wanted to also reiterate that when the person's telling you their story that you think this is really quite concerning, there's a lot of red flags, there's a lot of maybe threats to harm your client, or it might be that there has been weapons, or that there has been you know, high risk. So whether there's been choking or whether there's been any of those events, they're the ones where we really encourage you to support the client to ring the police, because they are able to assist them immediately. They're able to take out an application. They're able to look at should there be criminal charges if that's what the aggrieved wants. So it's your role to talk with the client to say, I'm really worried about what you're saying has happened to you, and we might need some extra support. And whether it is legal advice to support them to go to the police, but it is the police are there and they're very good at completing the documents as well. There's also these other connections. So DV Connect, obviously, it's a 24-hour phone line. There's Men's Line, that it's not 24 hours, but it is a very good service for men to ring. Maybe that they are a respondent and they have no idea what's happening, that this is a service that they can talk to. And there's the number of legal advice numbers there as well for you to refer to clients if they need that legal advice. So I think we need to get on to questions.
Yeah, let's get on to questions.
Sorry.
I'll tap in.
Okay.
Hi everyone again. Okay. So now we've got a bit of time for questions. I know we've got 10 minutes left of our allocated slot, but if you guys want to stay on, Fiona and Paula are happy to stay on a little bit longer.
Yep.
Yeah. So we can spend an extra 5 or 10 minutes answering questions. So on the sidebar, you can type in your question and we'll answer them.
I see there's a question there, who is supplying the interpreter and what part of the process is free for the interpreter? Is
is the free interpreter.
Is the free interpreter available for? So I can speak to that from a Queensland Courts perspective. Most certainly if a client comes into the counter and they're experiencing difficulty in communication, Queensland Courts can engage, and it will engage an interpreter to be able to interact and have conversations with registry staff. At that point, the registry staff will then engage an interpreter for the court process, and that is also free as well. So that's for the first court mention, and it can be by telephone or video link.
Okay, that's a great question. Okay. So somebody's also asking if they can get a copy of the presentation, and yes, after the presentation, we'll send out a copy of the PowerPoint slides to you all. And somebody's also asked, will it be on YouTube? And it will be. So I'll send out an email when it's available on YouTube to view. So you can refer to these ladies' advice again if you need to. Okay, so somebody's just asked, this is a great question. Is there laws in place or going to be in place that will help with sibling violence and or offspring violence?
So if it's sibling violence, it does fit in with a relevant relationship. So that's a family relationship. So obviously they can't be 16. That's a completely different legislation or it's parenting sometimes around that. But if they're adults, there is definitely there's elder abuse. So it might be a parent and a child. Or it could be two adults who are siblings. Yes, that fits within the family relationship. And that's something that the magistrates can make an order depending upon what are the facts in the application. So it's to make them safe. And sometimes it's just to be clear about this behaviour that's been happening in the past just has to stop.
Okay, so someone else has asked a question. If forms can be lodged at any court in Queensland, must it be heard in that court? Does this raise issues of safety if respondent has fled and is in a new area?
Okay, so perhaps we're talking about the aggrieved fleeing and being in a new area. I don't quite understand that question specifically, but I think the answer to that is yes, forms can be lodged at any courthouse in Queensland, and yes, the aggrieved. Okay, that's just been clarified. So, yeah. and yes, that is very common. Aggrieved are fleeing for their safety, and they're relocating to different areas around Queensland. So the documents can be filed at any courthouse in Queensland. The registry staff will list the matter at the local court, and the magistrate then has the determination as to whether or not that can be listed at another courthouse or transferred to another court within Queensland if necessary.
So it's important when you're deciding where do you file, because once you've filed, there is a stamp on where you've filed. So sometimes it might be you're completing the form, you're in regional Queensland, but you really want it to be filed in where that aggrieved was originally from, so that he doesn't know she's moved.
Correct.
And so that's fine. You can then say you need to file it in that court. Maybe it might be you want to file it in Brisbane or somewhere else. But if you're filing the application and it's a private application, then you need to know that aggrieved has to go to that court. So, or maybe phone link in, but it really is up to the court whether they'll accept a phone link. But yeah.
Yeah, so it really does come down to safety issue, what you were, and really thinking about the process before you lodge that application, which is what we spoke about at the beginning. But yes, you most certainly can make an application to appear by telephone in instances where safety could be compromised. But yeah, as Fiona said, please be aware that if you're going to lodge the form in another centre, it's going to be very obvious to the respondent when they are served by QPS with that document where that document has been filed.
And you can get legal advice, and whether there then is a lawyer that represents them, and that's the barrier that the aggrieved has, because the lawyer will appear, the aggrieved doesn't have to appear, and the lawyer also obviously keeps everything confidential.
Okay. So there's another question in here, a question that we answered before. This is a bit of an extension of that. The actual area I was wondering about is what happens if the son or daughter is very violent towards their parent.
So we actually have a lot of elder abuse occurring. So the person who's using the violence, though, has to be over a certain age. So it can't be a 14-year-old being violent to a parent. That's a different process altogether. But if it's, you know, somebody who's 25 and that they're using violence on their parent, yes, you can apply for a protection order. And yes, you can say this behaviour has to stop. You can even consider or ask the magistrate to consider to oust that person. There's a lot of things the magistrate thinks about in deciding to have that person leave the house.
Okay,
a really good question's just come up here, actually, I wouldn't mind answering. Will a protection order be considered a criminal record if it is approved by the magistrate? I work with older adults who are often concerned about the implications of their adult children, the respondents, in the cases of elder abuse. So that's a really, really good question. And the answer to that is no. It is at the initial stage, when it's at the application stage, even if the police are involved, it is a civil application and it will not appear on any criminal history whatsoever. If the respondent is served and contravenes the order and is then charged by Queensland Police, it then becomes an offence and potentially will appear on a criminal record. But at the initial stage, it is a civil application only.
And that's where the civil application is just saying, stop this behaviour, or move out and have some time away from the aggrieved, get some counselling, have maybe a behaviour change program in place so that behaviour into the future stops.
Okay, so another question has come through. Can an aggrieved be made to support pay the private legal costs of an accused should a DVO not be granted?
So that's asking for costs if at the hearing they're found that a protection order is not made. So this is an area where there's a very limited ability to have costs, and parties can withdraw if there is not sufficient grounds for their application. So that's where it's important that they get legal advice either before they file or on the first mention to work out, do they have sufficient facts? Is it a relevant relationship, or should they withdraw?
Okay, great. So another question, what happens if a DV1 form can't be served onto the respondent? Like if the respondent can't be found, does that mean the DV1 application is dropped?
You can probably answer that from the substitute service.
It is a bit of a problem that's happening in Queensland. So the police are the people who serve the documents, and so they also have to file an affidavit of service in the court before a final order can be made. So a temporary order can be made at that mention, and that stays in place until either a hearing or a final protection order is made. Depending on the magistrate is there an ability to have some service in another way? And that's where you'd be asking the magistrate, you know, if you've gone to 2 or 3 mentions and service still hadn't occurred. But often the magistrate, it could be the magistrate needs to inform the police to make sure that that service has occurred, and the police may have to talk with somebody, maybe the respondents in Western Australia or South Australia. That does take a bit of time.
Yeah, and there is provision under the Act, I think, that with an order by the court, the order can be explained or can be served, so for example, over the telephone, or have the conditions read out over the telephone. They're in extreme cases, but there is provision under the legislation for applications to be made to the court for what they call substituted service.
Yeah. And that's really up to the magistrate. So it's really important that you ask that there has been a couple of attempts for service and there's some reason that it hasn't happened. So, but often it is about just checking in with the police to make sure that they've been tasked with that and that they know the respondent's new address or where they're likely to be or where they work, or if there's been any change in that process.
But I guess the key point to take away from that is what Fiona said, and that is if there's a temporary order in place, it's up to the discretion of the magistrate, obviously, but that temporary protection order will continue for that period of time. So your client potentially will be safe during that period.
Okay, another question has just come through. How long does the process from beginning to end normally take?
Okay.
How long is a piece of string?
That's what I was going to say too. The domestic violence process can, well, it's very unique in each of the circumstances, isn't it, Fiona? It can be, and it goes back to the previous question as to how easy it is to locate the other party. Yeah, it can be resolved within 1 or 2 mentions, so maybe about 6 weeks. That is the best case scenario, so that if the respondent is served very swiftly and potentially consents to an order or doesn't appear and the order is made in their absence. There's also the possibility that the order is not served. It takes some period of time to be served, and there's also the other situation where the respondent may have been served and chooses to contest the matter.
Yes.
And that's, you can address that, Fiona, if you like.
So if it goes to hearing, there's a whole new process for that, and that does take time, and there are documents that will be exchanged between the parties, and that's where Paula was talking about subpoenas and affidavits, and that's a whole new area. So, but that can take a few months, probably 3 months would be the shortest time if it's set for hearing, really.
I think so, yeah. And once again, that comes back, that's a really great question that you can ask your registry staff in your local court. They'll be able to advise you what the current wait times are and the processes in your local region.
Okay, well, we've got a couple more minutes if you want to enter your questions, but if there's no more questions, I'll just move on to the wrap up for today. Give you a few more seconds. Okay, I think we'll wrap up. So there's, just with the rest of the slides, there's a few links on there to the forms, and there's also a nice video explaining the court process. Now, these are Legal Aid's office locations. You may or may not know where they are, but there's a handy map for you, and phone numbers there for our main referral lines. Okay, we also have, Legal Aid has our e-newsletter, which is online. So if you want to stay up to date with what's happening at Legal Aid, please check that out. And we also have a number of Legal Aid publications, and we've just released 3 new publications for DV month actually, which is very exciting. So go online and they're available now to look at, and hopefully they can help you in the services you provide. Here's some more. So this webinar, as I've already said, will go up on YouTube. So under our playlist and legal information webinars for community workers. So please have a look. If you can't remember something you've learned today, you can go back and have a look at that video. Legal Aid has a great webinar program. We've got 12 webinars we run a year usually, and our next webinar is on 28th of June, and it's about the Australian Financial Complaints Authority, and we've got senior lawyer Paul Holmes with us for that one, and we're also having a representative from the AFCA. So if that's the area that you've got clients that are having issues with in terms of accessing that complaint system, then please subscribe to our mailing list online, and you'll get notified when that webinar is available. So if you've got any questions about legal aid or anything that's been said today, please feel free to send me an email. My email is community.legalaid@legalaid.qld.gov.au. And if you've got any questions for Paula or Fiona, just shoot them through there and I'll distribute them out. That's great. Okay, thank you very much, guys, and thank you very much to our presenters for coming today. It's been really great.
Thank you.
Thank you. We'll see you later.